Bismillah, alhamdulillah, wassalatu wassalamu ala rasulillah wa ba'd. Inshallah, just picking up from where we left off last week, just very quickly. We'll continue our discussion of textual interpretation. I just briefly wanted to take a look at the slides from last week, because obviously there was an error in them. So I've moved now wish or tamannin under talab. So this is what this is what it was supposed to look like. So here you can see it is under basically in the right place. Okay. Okay, so that basically out of the way. We were talking about Haqiqa and Majaz. Of course, we have Haqiqa Lughawiyya, Haqiqa Shar'iyya, Haqiqa Urfiyya. Just briefly to touch on this last point. Obviously, with the Haqiqa Shar'iyya in particular is very important because the Sharia texts, their primary purpose is to explain realities of the Sharia. And so the default then when dealing with the Sharia text is that any word that is mentioned that has a Haqiqa Shar'iyya, we should assume until there's some evidence indicating otherwise, that what is intended is the Haqiqa Shar'iyya. So therefore, whenever Salah is mentioned in the text, the default will be that it is intending the well-known Salah that begins with Takbir and ends with Taslim. There are exceptions where you will find certain texts that mention Salah, and what is meant is dua. وَصَلِّ عَلَيْهِمْ إِنَّ صَلَاتَكَ سَكَنٌ لَهُمْ, meaning make dua for them. Okay, so now moving on, Imam al-Haramain has categorized the relationships between Haqiqa and Majaz into certain categories. There's a bit of an issue here with this. Haqiqa and Majaz, when we were explaining it before, basically said that Haqiqa is sort of the literal usage of something, and Majaz is a figurative usage. And then even when you get into the subcategories of Majaz, particularly in Ilm al-Balagha, you'll find that there's very specific terms for very specific things that don't necessarily translate directly into English. If you try and translate them directly into English, it doesn't always work. In any case, let's look at what he has mentioned. It says, المجاز إما أن يكون بزيادة أو نقصان أو نقل أو استعارة. Majaz could be by adding something to the text. It could be by subtracting something from the text. It could be by sort of transferring something, become clear what is intended with an example. Or it could be by a sort of a metaphor. So basically, these are sort of types of relationships between Haqiqa and Majaz. That what makes this Majaz is that you have done one of these things. And it will still be somehow tied to the original Haqiqa meaning of the text. This is basically, how he has explained it here. And obviously, this is a brief text, so he's mentioned it very briefly. But if you were to look in more detailed works of Usul Fiqh, or look in the books of the Balaghiyin, you'll find that in explaining the relationships between the various types of Haqiqa and Majaz, they list many types. So Az-Zarqashi in Al-Bahr al-Muhit, for example, his list reaches 36 different types of relationships between Haqiqa and Majaz. So basically, these would be 36 different types of Majaz, organized according to how they relate to the Haqiqa usage. And every Majazi usage, to be a valid Majazi usage, there must be some sort of relationship between it and the original Haqiqa usage. So Juwayni has mentioned 4 of them, and he has given examples. So he says, فَالْمَجَازُ بِالزِّيَادَةِ مِثْلُ قَوْلِهِ تَعَالَى لَيْسَ كَمِثْلِهِ شَيْءٌ. So the example that it gives for Majaz بِالزِّيَادَةِ is لَيْسَ كَمِثْلِهِ شَيْءٌ. This verse of the Quran, Allah subhanahu wa ta'ala says, there is nothing like unto him. So the addition here is the kaf. The kaf indicates being like something. So kaf basically is similar in meaning to the word mithl itself. So it's as if Allah subhanahu wa ta'ala said, laysa mithlahu shay. There's nothing like him. So when you say laysa kamithlihi shay, it's as if you're saying laysa mithla mithlihi shay. So this is addition in the sense that it is in meaning repetitive. It's obviously not repeating the same word, but it is a word that has essentially the same meaning. And so in a sense, this could be seen as being repetitive, and its function is to emphasize the meaning. So he's called this Majaz. But if we speak about literal and figurative in English, I'm not sure that this in English can be called figurative language. It is perhaps redundant. It is extra emphasis. But is it figurative? In English, you wouldn't necessarily call this figurative. But in Arabic, does it fall under what is called Majaz? Yes, it falls under Majaz. So, these translations of these terms, they're rough translations. The second example he gives, al-Majaz bin Nuqsan mithlu qawlihi ta'ala was'alil qaryah. Ask the town. So in English, this could be seen as being figurative. If we are assuming that we're basically treating the town as if it was a living being, and hence we're directing, hence the speaker here is saying, ask the town, as if the town is a living being. However, if you look at how Al-Juwayni has explained this, says this is Majaz bin Nuqsan. This is Majaz by subtraction. In other words, this is what in English would be called an ellipsis, that there's something that has been dropped, something that has been left unstated because it is understood. So then the meaning is actually what's ahl al-qaryah, ask the people of the town. And when we say this, was'al al-qaryah, it's simply understood that what is intended is was'al ahl al-qaryah. If what is understood from this is that people is essentially left unstated, so it means ask the people of the town, then the meaning that is understood from this is ask the people of the town. That's not figurative. So ellipsis, I'm not sure in English is something that would be categorized as figurative language. Although this particular example could be seen as being figurative if looked at in the other way that I mentioned. Then here he says we have Majaz bin Naql. Al-Majaz bin Naql kal-gha'it fima yakhruju min al-insan. Good. So this requires a little bit of explanation. What exactly is meant? So the usage of the word gha'it for human excrement. Ma yakhruju min al-insan, what comes out of the human being. He is referring here to excrement. Basically, when you use the bathroom and you do number 2. So this is the term غائط is used for it. The term غائط in the Arabic language originally is not used for this meaning at all. The term غائط in the Arabic language originally is the name for a place, for basically a patch of earth or a field, or I don't know what you want to say. Basically, it's a hollow or a depression in the ground, an area that is depressed, and so typically it will be surrounded by higher ground, such that you can basically, if you go there, if you're standing there or crouching there, the area around you will conceal you. And so it was the habit of the Arabs, all the way until the time of the Prophet ﷺ, that they would seek out such places for answering the call of nature. They would go out to a place that is essentially, it sort of has a natural sort of enclosure or covering, so that you can answer the call of nature without exposing yourself. So they would seek out these sorts of places to answer the call of nature. So this is in English, or we have in the Quran, Allah subhanahu wa ta'ala says, وَجَاءَ أَحَدٌ مِّنكُم مِّنَ الْغَائِطِ, or one of you has come from the غائط. Essentially, this is like in English saying, I've just come from the bathroom, or I had to go to the bathroom. It's not that you had to go to the bathroom because physically you needed to be in that place, because some, I don't know, something has okay, it's not very good. I guess you physically have to be in that place, but it's not that you went to that place for the sake of going to that place. It's that what is meant is that you went there to answer the call of nature. And so oftentimes this is something that you sort of have a double meaning can be intended. You could say, جاء أحد منكم من الغائط, and intend someone is coming from the غائط, having answered the call of nature. So you have the literal meaning is sort of implied, as well as this figurative meaning. So this is figurative speech in that, okay, so this is the original usage. This is the original meaning of the word غائط. Now this word غائط, because of its association with as this place being the place that people go to the bathroom, it began being used as a euphemism for answering the call of nature in Arabic, and it became so widespread that it came to be used as a name for excrement itself, will be called غائط. So the Majaz by transferal or transference here is that the original word means something that is associated with the new meaning. Not that the new meaning, which is excrement, that type of place, it might not be used. In some cases, you might find a place like that that's no use for answering the call of nature at all. So it's not that intrinsically that place means excrement, or that word means excrement, but there is obviously this association. The two are related in this way, and so the name of the place has been transferred to the name of the activity that is done there. So you might say تغوط to the actual act, and غائط for the actual excrement itself. We have the fourth example, the fourth category. It says والمجاز بالاستعارة كقوله تعالى جدارا يريد أن ينقض. A wall that wants to fall down. This is from the story of Musa alayhi salam with Khadr. Story of Musa alayhi salam with Al-Khadr in Surah Al-Kahf. And overwhelmingly, if you look in the books of tafsir, you'll find almost all Mufassirin, they say that this is an isti'ara. You have some contemporary scholars who have commented on this verse, saying that, who's to say that the world doesn't have a will, an irada, and that therefore what is intended is jidaran yuridu an yanqad, the wall that wanted to fall down, literally a wall that actually wanted to fall down. I would be more sympathetic to this idea if it had been presented in a way that it actually makes an argument that there's a qarina indicating that that the zahir actually is intended. And someone could make that case. Saying, look at the entire context of Surah Al-Kahf. أم حسبت أن أصحاب الكهف والرقيم كانوا من آياتنا عجبا. That the story of Ashab al-Kahf, something that is strange and wondrous. And then all throughout the Surah Al-Kahf, you have accounts of things that are strange and wondrous, including obviously the story of Musa and Khadr itself. So maybe you could use that as a qarina. Though in this particular case, I don't think for this point, I don't think it's a very strong qarina. But had someone made that case, then I would be more sympathetic to it. But simply to say that this is the zahir, because the asal is that we have to take everything with zahir. This is really an unmerited sort of ghulu, sort of going to extremes in understanding texts literally. Concerning the verse "Laysa kamithlihi shay," there's some ikhtilaf amongst the mufassirin about how do they do tawjih of it, and how to reconcile the idea of the kaf essentially being the same meaning as the mithal. Why is this particular, what is basically the sort of linguistic explanation or justification for using this sort of expression? What you'll find Ibn al-Firkah in his commentary on al-Waraqat, and in similar from al-Mahalli in his Sharh of al-Waraqat as well. Essentially what they've said is that this is majaz. Why is it majaz? Because we're saying laysa mithla mithlihi shay. There is nothing like the likeness of Allah subhanahu wa ta'ala. So they say that, well, if you look at this is the zahir of this is that you're affirming that Allah has a likeness, which of course is kufr to say that. And then you're negating that his likeness, the one who is like him, has anyone like him. Others have basically said that no, this is simply it's an Arabic expression. It's an Arabic expression that the Arabs sometimes use ka mithli as ziyada fi at-ta'kid, and it's not considered redundant because it's something that dhawq, something that it in terms of how it sounds acceptable. Because when you say laysa mithla mithlihi shay, obviously you hear that and you're like that sounds redundant, it sounds kind of silly. But when you say laysa kamithlihi shay, or they have various examples that they give from Arabic poetry, where they've used kamithlihi. This is it's كمثل, the two don't sound alike, so they go together just fine. And it's understood that it's simply, this is an emphasizing that there's nothing like him. So it's just more emphatic in negating this. The Zamakhshari actually puts forward a sort of a little bit of a different approach. It says that this is not simply repetition for the sake of ta'keed. He says that that there are many examples in the Arabic language where people say, for example, one of the examples he gives is mithluka la yabkhal. The likes of you will not be stingy. In other words, saying that someone who resembles you will not be stingy. So it goes without saying that you would not be stingy. So they're actually negating it from someone, they're actually negating this quality of stinginess from someone else, implying that you are not stingy. So he gives various examples for this. And basically he says that when you say laysa kamithlihi shay, he says that this has become so common. This has become so common that in their expressions that it's simply understood that when you say this, you're not actually first affirming that no, this person, he's like you, and he doesn't do this, so therefore you shouldn't be doing this either. This is understood. This is understood. So the fa'idah of the comparison remains in the expression, which is that it is a sort of emphatic negation. But it doesn't imply this idea of there being someone like him. You're not necessarily, because when you say mithluka la yabkhal, someone like you, the likes of you does not do such, does not show stinginess or behave stingily in a stingy fashion. It's clear that what is intended is to negate it from this person, not from someone who is actually out there who actually resembles him. This is understood, and it's a more emphatic way of achieving that meaning. But in any case, this is very briefly about basic mithli shay. So now we come to what is a very important discussion. It's one of the fundamental discussions of usul al-fiqh, is commands and prohibitions, al-amr wal-nahi, or al-awamir wal-nawahi, commands and prohibitions. Obviously, I'm talking about taking rulings from the shari'ah. This is wajib, this is haram, this is mustahab, this is makruh, this is mubah. Then obviously, commands and prohibitions are essential to how we understand the Sharia and how we know from the Sharia what it wants us to do, and what its rulings, what those rulings are. So Imam al-Haramain says, وَالْأَمْرُ اسْتِدْعَاءُ الْفِعْلِ بِالْقَوْلِ مِمَّنْ هُوَ دُونَهُ عَلَى سَبِيلِ الْوُجُوبِ وَصِيغَتُهُ افْعَلْ وهي عند الإطلاق والتجرد عن القرينة تحمل عليه إلا ما دل الدليل على أن المراد منه الندب أو الإباحة. So this is the translation from the translation that I've given you guys. This is cut and pasted here, but in other places you'll see that I've actually retyped it. A command is a verbal demand. الأمر استدعاء الفعل. So استدعاء الفعل بالقول. بالقول, this is where it's getting verbal, that it is with words. It's استدعاء الفعل, you're demanding someone, you're requesting of them that they perform an action verbally, بالقول. The reason they mention verbally is they say that, well, this excludes um, written commands or gestures and things like that. So in particular, when we speak about amr, we're speaking about verbal commands. ممن هو دونه, from someone of lesser status, which is obliging and inferior. An inferior meaning someone of lesser status to do an action. So this idea of it's ممن هو دونه, this is to account for when you make a request from someone who is above you. This is a request, a plea with regards to Allah subhanahu wa ta'ala. It's dua. Even though the expression you're using might be the same. Even the expression you're using might be the same. So for example, when you say, "Oh Allah, give me a child," so this you're using the imperative form, which is basically the command form. But is this is a command? Are you commanding Allah subhanahu wa ta'ala? No, you're making dua to Allah subhanahu wa ta'ala. So when you use the imperative form of the verb, when you use it for someone who is of higher rank than you, this is not a command. When you use it of someone that is of equal rank to you, this is also not a command. This is just a request. And the term that they use in the usul al-fiqh books say this is iltimas. You're seeking from him that to do this. You're not commanding him. Command is when it's to an inferior. Although there's ikhtilaf about this, because some of them said that it doesn't have to be from an inferior. I mean, you could theoretically have a slave. Command his master, do this. You better do this. It might be considered stupid for him to do so. He might, but the fact that he can do it and it would be understood that he is commanding him indicates that this is, not as intrinsic to the definition of what makes something a command. So he then says, وَصِيغَتُهُ على سبيل الوجوب. على سبيل الوجوب because استدعاء على سبيل الوجوب. It is you're requesting them, you're seeking from someone to do an action, obliging that action. And that sort of has been captured in the translation as obliging. A command is a verbal demand obliging an inferior to do an action. So the word order is sort of changed around, but basically all the components of the definition given are there. So then he says, وَصِيغَتُهُ إِفْعَلْ. The verbal form that indicates a command is if'al, or the imperative form of the verb. This is the primary sigha, the primary form that commands take. Otherwise, there are other forms for commands that are mentioned in more detailed works. But the primary is do not do. If'al literally means do. You might be familiar, for those of you who studied, Arabic grammar and sarf morphology, that it's the habit of the grammarians to use derivatives of the root fa'ala whenever they want to show a pattern, a morphological pattern that words take. They will use fa'ala. So they use that sort of as the generic sort of model. So if'al is from the verb fa'ala. It literally means do. It's a command, do. This is the command form. The particular morphological form that each command takes will vary from word to word, and this is something that you would study in sarf. But essentially, the idea is if'al means do, and every verb has a imperative form that is equivalent. So this is known as sighatul amr, or the verbal form of commands. وهي عند الإطلاق والتجرد عن القرينة تحمل عليه إلا ما دل الدليل على أن المراد منه الندب أو الإباحة. So he says that when the command, meaning this verbal form, this imperative, when it is unqualified, in the itlaq, meaning it is amr mutlaq, doesn't have anything qualifying it that would indicate that sort of explicitly indicate that this is actually intended as a recommendation, for example, or simply permission to do a certain action. In the itlaq, والتجرد عن القرينة. So when it is unqualified and in absence of indications to the contrary, it is interpreted as obligation. تحمل عليه أي تحمل على الوجوب. So in other words, we have what is called, sometimes you see this expressed as الأمر المجرد عن القرينة, or simply الأمر المطلق. So الأمر المجرد عن القرينة is an amr that has no accompanying indications. It has no qara'in. There are no external indications, meaning when I say external, I mean external to the verb itself. There are no external indications that would indicate that some other meaning besides obligation is intended. This is called al-amr al-mujarrad an al-qarina. It's a command that has no external or accompanying indications that would indicate a different meaning besides obligation. Or simply it will be called al-amr al-mutlaq or al-amr al-mutlaq an al-qarina, an unqualified command. When you have the command, the verb form, the imperative form of a verb, and it is unaccompanied by any qarina, any indication of an alternative meaning, the default rule is that the command should be interpreted and understood to be an obligation. إلا ما دل الدليل على أن المراد منه الندب أو الإباحة, except when we have some evidence that indicates recommendation is meant. So the actual ruling is that it is mandub, mustahab, something that is recommended but not obligatory, or that it is simply something that is permissible. This brings up a couple of questions. Is there ever, so we actually have now the principle that is mentioned here. Sometimes you will find it expressed as al-amr yaqtadi al-wujub. A command dictates obligation. So anytime you have a command, it is understood as being obligatory. What is meant is al-amr al-mutlaq or al-amr al-mujarrad an al-qarina. Because if there is a qarina, then by agreement, we first look at what does the qarina indicate. Or if there is multiple qara'in, we look at what are these qara'in indicating concerning this imperative. Is it intended as an obligation, or is it intended as a recommendation, or simply as giving permission? So when there are qara'in, we look at the qara'in first. And if the qara'in, if the indications for one of these interpretations is stronger, we go with that interpretation. Or so then with this principle is applied where we find no such qara'in, we find no such indications. Or it can be applied where we have various indications, some of them that sort of tip the scale towards wujub, and some of them that tip the scale towards nadb, for example, recommendation. But The faqih who's looking at this case feels that, the indications here for either opinion seem to me to be relatively equal. It's a wash between them. So I will resort to the default, which is to understand this command as an obligation. But that raises a very important question. What is a qara'in? What exactly are qara'in? This is actually an interesting question because qara'in are not really typically defined in the books of usul al-fiqh. Qara'in are typically not defined in the books of usul al-fiqh. Or if you get a definition, you get a very general sort of definition that it's something that is accompanying the text and it gives some sort of indication, or it's a sign that indicates something that is not obvious, or various meanings like that. They don't clearly define qara'in when it comes to qara'in that divert an amr to nadb or istihbab. What exactly are qara'in? And I'll return to that in a moment. Let's take a look at these categories. So based on what we've seen so far from Imam al-Haramain, commands can indicate obligation, they can indicate recommendation, and they can indicate permission. So you have, for example, the command, وَأَقِيمُوا الصَّلَاةَ. So obviously this is an obligation. Now we know that this is an obligation because this is the default, but obviously we also know that it's an obligation because there's ijma, there's explicit text about the obligation of the 5 prayers. So in this case, we're not taking the obligation وَأَقِيمُوا الصَّلَاةَ simply from the expression. We're taking it simply from the expression. We have a host of other texts that make it indisputably clear, plus ijma qat'i, that 5 prayers a day are not just obligatory; they're the very foundation of our deen. So this is an example, and sometimes in the books of usul fiqh you'll find that this example or similar examples are given, but it doesn't help us It's not necessarily that. If you think about it, it's not necessarily that helpful for understanding the idea of al-amr al-mujarrad and al-qarina. Because this is not an amr that is mujarrad and qara'in. This is not an amr mutlaq. This is an amr that absolutely, without a doubt, we know that only obligation is meant because we have all this evidence. Same thing for atu zakah. Atu zakah, there's no doubt about its obligation. We have ijma, we have countless texts that point to us. We have texts that speak about the punishment of the people who don't give their zakah in the hereafter. Sahaba made war against them. If that's not an indication of obligation, then what is? So this is not exactly an example of al-amr al-mutlaq and al-qara'in, or al-amr al-mujarrad and al-qara'in. This is an amr that has accompanying indications. For nadb, I've given 2 examples. Both of these are common examples that are given. فَكَاتِبُوهُمْ إِنْ عَلِمْتُمْ. I said فِيهِنَّ. I just typed it. إِنْ عَلِمْتُمْ. I just can't catch a bird. إِنْ عَلِمْتُمْ فِيهِمْ خَيْرًا. فَكَاتِبُوهُمْ إِنْ عَلِمْتُمْ فِيهِمْ خَيْرًا. This verse, what it means is Mukativa. Mukativa is a type of agreement that a master makes with the slave to free him. It says that you work for me for this amount of time, or you work for this amount of time and pay me in installments this amount of money, because slaves would oftentimes if they had a profession, they would work and earn money So he's saying that, over this amount of time, I will free you if you pay me this many installments. Whatever the details of the agreement that they might come to. This is known as Mukativa, and its basis is in this verse. فَكَاتِبُوهُمْ إِنْ عَلِمْتُمْ فِيهِمْ خَيْرًا. If you know them to have good in them, then do this Mukativa with them. It's in the command form. Generally speaking, most of the ulama have understood this to be a non-binding command. So this is a recommendation. This is a recommendation. What is the qarina? That this is not obligatory. It's worth noting that there's actually ikhtilaf about this. There is an opinion that this is an obligation. There's an opinion that this is an obligation, but many scholars have understood this to be a recommendation. So the question then is, what is the qarina here? Anyone care to venture a guess? What is the qarina? Nobody? Okay, so the qarina is one that that is typically mentioned. It's one that maybe is going to sound quite insensitive to modern sensibilities, and Muhammad Abdul Mun'im is right there to trample on those modern sensibilities. So what they typically say is that the slave is the property of his master, and typically speaking, with property, the general rule with property is that you're free to do with your property as you choose. Obviously, there are certain rules and regulations for anything, but as a default, if you own something, you're not under the obligation to give it away. You're not under an obligation to sell it. You're not under obligation to buy from others. It is your choice what you do with your property. So they say that this indicates that this command is not being given as an obligation. It's not being mentioned as an obligation. It's something that is recommended. But as I said, there is actually ikhtilaf about this command. Is it an obligation or permission? And this is one of the, or is it an obligation or a recommendation? This is one of the tricky things about giving examples for this issue is, if I give you an example of a command that is agreed on to be an obligation or agreed on by all scholars to be a recommendation, then anyone could come and say, well, there's ijma that this is an obligation, and so therefore that's a qarina. There's an ijma that this is a recommendation, and so therefore that is a qarina. And if there's ikhtilaf, then that would mean that those who differed, they looked at the issue, and some of them said, well, here's a qarina that indicates nadb. And we can assume that if someone is countering and saying, no, this is wajib, he ideally is aware of those who are saying that it is mandub, and has an idea of the qarina that they're looking at, that they feel indicates recommendation. And he has, in his own mind or in his assessment, a different qarina which he thinks is stronger. It might be possible that in some cases might be you might have individual fuqaha who have interpreted a certain command to be obligatory simply based on the general principle that al-amr yaqtadi al-wujub, and they're simply unaware of any other qara'in. But oftentimes the expectation would be, no, they have a good idea that, of those who are saying that something is wajib, particularly if it's a widespread call, that they would be aware of those who are saying that it is mandub, and they have their own qarina that they're looking at, which they feel is stronger. Or at the very least, they look at the qarina that the opposing side has mentioned and simply conclude, this qarina is just not very compelling, and I will stick to the default ruling. But you can see how this creates sort of a dilemma, because the idea of al-amr al-mujarrad and al-qara'in is that there are no qara'in. If ijma' is a qarina, and you'll find people use ijma' as a qarina, because sometimes they will say that this amr is mandub, the default of amr is wujub, so why are you saying that this is mandub? They said ijma'. So they're treating ijma' as a qarina. So if any awamir that there's agreement on, there's an ijma', which is a qarina. Any awamir that there's disagreement on, we can assume that some of the fuqaha who are saying, who are taking a call other than wujub, saying that there's this qarina present. So when do you have an amr that is free of qarina? Do you see the dilemma that it's sort of a paradox here, that when it actually is an amr free of qarina? Is there such thing as amr mutlaq? I'm not saying that there's not or that there is. I just want to give you some food for thought. Now, I mean, in response to what I've said, someone could say, and I think this would be a good argument, is that ijma' happens after the fuqaha have looked at the nusus and interpreted them. Right? Ijma' happens after the fact, not before the nusus. When these verses were revealed, so for example, if we say وَأَشْهِدُوا إِذَا تَبَايَعْتُمْ, وَأَشْهِدُوا إِذَا تَبَايَعْتُمْ means have witnesses bear witness when you engage in buying and selling. So if we were to look at this just generally into this amr mutlaq, we'd say that this is asking us to have witnesses. This is a command, therefore it's an obligation. As you see here, I've put it under najm. Vast majority of ulama have said that this is mandub, and I think an ijma' has been claimed on this. I think there actually might be some who've quoted a view of wujub for this, but I think an ijma' has been claimed on this. Let's assume for the sake of argument that there is an ijma' on this. And there might very well be, because the idea that you should have witnesses for every sale, that you have two people come and bear witness to every sale that you engage in, is obviously, it's really odd. So there might very well be a valid ijma' on this. So let's assume for the sake of argument that there is an ijma'. So when this verse was revealed to the companions, did they say, oh, there's an ijma' on this, so therefore we know that this command is not intended to be an obligation? How could they have agreed on its interpretation of this command if the command hadn't come yet, right? So ijma' is something that happened after the revelation of this verse, assuming that there is an ijma'. It's something that would have happened after the revelation of this verse and the interpretation of this verse. And the fuqaha of the Sahaba and the fuqaha of the Tabi'een looking at this verse and concluding that this verse is intended for nadb. It's intended as a recommend. This command in this verse is intended as a recommendation, not as an obligation. And so therefore, this is a recommendation. And then when you observe all the fuqaha, you find that all of them have agreed on this. So then you say that, well, this is a qarina. Yeah, it is a qarina, but it's a qarina that came after. It's a qarina for you, but it wasn't necessarily a qarina for them. This discussion is actually much more complicated than this, but this is all for the purpose of just sort of giving a little bit of food for thought about how this works. Okay, so examples for ibaha, we have wukulu washrab, eat and drink. Obviously, there's no nisab for eating and drinking. You're not sinful if you don't eat 2 pounds of steak every day. It's not a sin. It might be mahroom. It's not a sin. There's not any so this verse is intended simply to let us know that that eat and drink and enjoy the halal that Allah subhanahu wa ta'ala has given you. Another example, وَإِذَا حَلَلْتُمْ فَاصْطَادُوا. When you have come out of the state of ihram, halaltum means when you become halal, meaning you've come out of the state of ihram. When you have come out of the state of ihram, then hunt. So, as far as I'm aware, Allah alam, no faqih has ever said that your manasik of Hajj are incomplete until you come out of your ihram and you go on a safari. Allah alam. I'm not aware of any faqih who has said this. So clearly, ijma. I think it's pretty clear here that there is ijma that this is not obligatory at the very least. Some might say that it's recommended. I don't know, is there someone who says that it's recommended? But it seems pretty obvious that that it's not obligatory. So this is indicating permission, and the reason that the command has been given, is because there is a prohibition against hunting during ihram. There's a prohibition against hunting during ihram. Now, this is actually mentioned as one of the qara'in, and oftentimes mentioned as an issue in the books of usul fiqh, is al-amr ba'd al-hadar, the command that comes after something has been made unlawful. That command, so many fuqaha say that command, that al-amr ba'd al-hadar indicates ibaha. There's some dispute on this. You have other opinions. Another opinion is that it doesn't actually indicate ibaha so much. It doesn't indicate permission so much as it indicates a return of whatever is being commanded to its default state before its prohibition. So if it was something that was recommended before prohibition, it becomes recommended. It returns to its normal state. If it was obligatory before prohibition, it returns to its obligatory state. So you enter a state where this particular thing, this particular obligation, you're not allowed to perform it, but it returns to being an obligation once the prohibition has passed. But in any case, many fuqaha, and for the time being, this might be simpler for you to remember, that al-amr ba'd al-hadar indicates that the command that comes after something has been made unlawful indicates that it is permissible. Another example, فَإِذَا قُضِيَتِ الصَّلَاةُ فَانْتَشِرُوا فِي الْأَرْضِ وَابْتَغُوا مِنْ فَضْلِ اللَّهِ. When the salah is complete, spread out through the earth. This is referring to Salatul Jumu'ah. وَابْتَغُوا مِنْ فَضْلِ اللَّهِ, and seek of Allah's bounty. This is referring to going out and doing business and engaging in your worldly affairs. And again, they were prohibited from doing so during the salah, during Salatul Jumu'ah. And so it was made, this verse is telling them that once the salah is over, it is lawful for you. Okay, Saad has asked a very good question. I want you to hold that question because once we've had a chance to discuss all of this concerning Awamir in a little bit more detail, hopefully the question will be more appropriate then. Okay, so otherwise it's an excellent question. Okay, so now I, I want to break down what we've looked at from a couple of different angles. Firstly, it's worth noting that this opinion that wujub is the default for awamir, this is according to most scholars. It is the view of the majority of scholars of each of the four madhabs, meaning the majority of Shafi'i scholars have said this, the majority of Hanafi scholars have said this, the majority of Maliki scholars have said this, the majority of Hanbali scholars have said this, and so forth. They disagree, however, those scholars who have said that that wujub is the default, they disagree. Where is this default ruling of Sirat al-Amr, where is it taken from? Is it taken from the language itself? Or is it something that we're taking from the shari'ah? Or is it something that is coming from logical deduction? There's long discussions about this. It's not my intent to actually get into those discussions. They're well beyond the scope of what we're doing in this class. But there is a discussion about where does it come from. I want to look at some of the shari'ah arguments that are put forward for this point. I've mentioned one of them here on the screen. Mention one of them here on the screen. فليحذر الذين يخالفون عن أمره أن تصيبهم فتنة أو يصيبهم عذاب أليم. So let those who go against the command of the Prophet ﷺ be weary lest a fitna and a trial afflict them, or they be struck with severe punishment. And there's a narration from Imam Ahmed that he comments on this verse. Says, do you know what is fitna? It's shirk. Meaning they could be put to trial in their religion such that they leave the religion. Or they could face in the hereafter severe punishment for going against the command of the Prophet. Mentions Amr. Seems pretty clear that Amr is obligatory. Follow. It's a very serious matter. Another one that is oftentimes mentioned is the hadith of the Prophet ﷺ. The hadith of the Prophet ﷺ, لولا أن أشق على أمتي لأمرتهم بالسواك مع كل صلاة. Were it not that this might create hardship for my ummah, I would have commanded them to use siwak at the time of every prayer. It says, لولا أن أشق على أمتي. In other words, I haven't commanded them. I would have commanded them. We say that this indicates that Prophet ﷺ wants us to know that he's recommending us to do this, but it's not an obligation. And since he used the word لأمرتهم, I would have commanded them, this indicates that a command would then indicate obligation. So Amr essentially equals as default obligation. Another text, ما أمرتكم به فأتوا منه ما استطعتم. Whatever I have commanded you, do whatever you are able of it. Meaning, only in the case of inability are you excused for not fulfilling a command, Amr. And again, the word Amr is used. In all three of these texts, the word Amr is used. There might be some other texts that are used for this sort of istidlal, but these are to illustrate examples of the sort of textual evidences that are used. There are other textual evidences that are used. So these three in particular are interesting because they all have the word Amr in them. What do you think of this istidlal? Is this a compelling istidlal? Okay. So, anyone? Because Saad says it makes sense to me. Anyone else? Saad is the only one who has an opinion. Okay, let's put, unless somebody is typing out a long explanation of why they agree or disagree. Okay, so you can still argue that this refers to when there's a qarina that indicates wujub rather than mutlaq. Okay, that's, I guess, one way of looking at it. I think there's a more important point here, but okay, so the rest of you, do you agree with this istidlal or disagree? Yes, no. Do you agree with this istidlal or disagree? Saad, you can also say yes or no, because you said it makes sense. Doesn't mean that you have to agree with it. Okay, Saad agrees with this istidlal. Okay, Abdul's iPad also agrees. I'm sure that's not its real name, but Muhammad Abdul Mun'im says Majaz. So I'm assuming that you're saying you don't agree with this istidlal. Okay. All right. I get, so Majaz in Abdul's iPad. Okay. Okay. Yeah, this is a Majaz. That's right. He's not actually his iPad. He just happens to be attached to his iPad. So this is Majaz bin Naql. Okay, so Safwan agrees. All right. So I actually think that this istidlal is very poor, because all of it is on the assumption that sigat if'al is an amr. Intrinsically, by default, it is an amr. Because the texts mention amr. This particular sigha, we've called it sigat al-amr. What if somebody decided to call it sigat al-talab instead? Or simply sigat if'al? Do you understand what I'm saying? We could have said that this is the imperative is it's simply a request. It's simply seeking something. You could be seeking something from someone to do something ala sabil al-wujub. You could be seeking from them to do ala sabil al-nadb. Which is why there is actually an opinion among some usuliyin that, and particularly some of them argue that regardless of what the default in the Sharia text is, that in the language, it doesn't indicate obligation. In the language, it doesn't indicate obligation. It only indicates obligation when there are qara'in indicating obligation. That's in the language. I'm not talking about in the Sharia. And so when we call that sighat al-amr, that's not a dalil in the Sharia that any instance of if'al is simply assumed to be an amr. We called it that name, sighat al-amr. The Sharia did not call it that name. And so when it says فَلْيَحْذَرِ الَّذِينَ يُخَالِفُونَ عَنْ أَمْرِهِ, it very well and mean that those who go against his obligatory commands. Amr meaning an obligatory command, as opposed to a recommendation, which could also be if'al. Both of them could be if'al. In fact, when if you want to tell someone to do something as a recommendation, you use the imperative if'al the same way that you use it for an obligation. So I don't think that this is that these sorts of textual arguments are necessarily compelling as an argument for wujub. In any case, this is just something I wanted to throw out there as food for thought. Okay, so this is in the language. This is in the language. The question is, does that mean that in the shari'ah, the ruling is still the ruling is also that it doesn't have a default between wujub and nadb? Not necessarily. Not necessarily. I'll just say at this point, suffice it to say that the majority view of all of the scholars from each of the four madhabs is that the default is wujub. The default is wujub. However, what I'd like you to take away from this is that even if we say the default is wujub, you should understand that the dalala of these siyagh, this dalala of these expressions, the meaning of these expressions, it can very easily go towards nadb or less so towards ibaha when there are qara'in indicating that. So this is going to be valuable to us in two respects. One is, number one, what you'll find, and I've seen this with many contemporary scholars and muftis, that the way that they approach interpretation of the texts is that they have oftentimes an exaggerated tendency to treat all commands as meaning all imperative verbs, all commands that come in the text as being obligatory, even when there are qara'in indicating that it is not, and likewise all prohibitions treating them as something that is haram. So an example of this, you have some scholars say, so for example, the Prophet ﷺ says, إذا دخل أحدكم المجلس فلا يجلس حتى يصلي إذا دخل أحدكم المسجد فلا يجلس حتى يصلي ركعتين. When one of you enters the masjid, let him not sit until he prays 2 rak'ahs. So the vast majority of scholars have said that this is recommended to pray these 2 rak'ahs before sitting. And some scholars, such as Ibn Rajab, have even claimed that there's ijma on this. A minority of scholars, particularly amongst contemporaries, have taken the view that no, this is an obligation. You cannot sit until you have prayed 2 rak'ahs. There's no evidence to understand this in any other fashion. The Prophet ﷺ has prohibited sitting until you pray 2 rak'ahs, so it's haram to sit until you pray 2 rak'ahs. And so this sort of exaggerated emphasis on the idea of the default being wujub. Yes, the default is wujub, fine, no problem. But even if we say the default is wujub, the scales, can the between wujub and nadb that tip it such that wujub is a little bit more likely, and such as the default. It's just barely. So anytime you have a command, there's a qarina indicating nadb, and there's no qarina indicating wujub. You shouldn't hesitate to understand that this command is mandub. And likewise with prohibitions, when you have a qarina indicating that it is actually makruh rather than muharram. What leads some people to have this sort of exaggerated concern is that they don't realize how fluid or how flexible the possibility, the usage of this expression or this form is. I think if they appreciated how flexible it is, particularly from a linguistic perspective, that anytime you have the sirat if'al being used for someone higher, the default is actually that it's not a command. It's a dua or it's a plea or whatever you want to call it. And with your equals, it's just a request. Now, something that you could point out as well, in this case, in the case of the Sharia, the commands are coming from someone of higher status, Allah subhanahu wa ta'ala, and His Messenger sallallahu alaihi wasallam. That is a qarina. In and of itself, that is a qarina, absent all other qara'in. So that's one important thing to take note of. The other thing that is important to take note of is that this idea of the default is wujub. I'm not saying that this is wrong, but as I said, it's almost more of a hypothetical proposition than it is a practical one. So I think that most cases, most texts, if you look at them carefully, you will find qara'in. There might be textual qara'in, there might be qara'in coming from other texts, or there might be a qara'in that rely on rational analysis and deduction, looking at the principles of the Sharia. So, for example, وَأَشْهِدُوا إِذَا تَبَايَعْتُمْ. We mentioned that this is basically supported by Ijma. It's not just supported by Ijma. Obviously, this is a very sort of clear example because the Prophet ﷺ used to buy and sell, and he wasn't having witnesses bear witness to every transaction he engaged in, nor were the Sahaba doing this. They were doing this with the Prophet ﷺ's knowledge. So clearly, this is not how they understood it. But even if you just stop and think, why was this command given? Why was the command given? What purpose does it serve? To have witnesses bear witness to a financial transaction. Why did Allah command this? Okay, to prevent cheating. That's one way to put it. Basically, the idea is, that's one way you could put it, to prevent cheating. Another way you could frame it is that in case of dispute, people's financial rights are protected if they're witnesses. So this is something that Allah subhanahu wa ta'ala has encouraged us to do to protect our financial rights. But is it necessary for us to do that? It's not. I mean, if I pop into the grocery store and buy, some candy for 25 cents or something like that. And afterwards, if a dispute happens and he says that, oh, you didn't pay for this candy, or I go home and I find that instead of 25 cents worth of candy, he's giving me 10 cents. Big deal. Am I going to go back and call for the two witnesses to come and bear witness that this is what we had agreed on and this is what he had given me, and maybe file a court hearing. I'll just say, okay, here, take 15 cents and give me what I wanted. No big deal. It's not a misunderstanding. It happens, and life goes on. Obviously, so if you just consider what the purpose of it is, the purpose of it is something. It's a recommendation. It's a recommendation that Allah subhanahu wa ta'ala is encouraging us to do, so that disputes don't happen. It might be that a person goes through his whole life engaging in financial transactions and never actually gets into a dispute without having witnesses. I mean, it's something that it's recommended. When you understand the purpose of its legislation, you can understand that it's something that is recommended. Yes, we know that the Prophet ﷺ was not doing this in all of his sales, and the Sahaba were not doing this. And so that makes it very clear. But if we did, suppose that for the sake of argument that we didn't know that, is not the purpose of this obvious, that it's something that is a recommendation? And understanding the purpose, we can understand that it is recommendation. So I think with commands and prohibitions, the very least that I will say is this principle is a valid principle. Al-amr yaqtadi al-wujub. But the job of the faqih is to search for qara'in, search for as many qara'in as possible. And then when he has exhausted his search for qara'in, then he resorts to the default principle, al-amr yaqtadi al-wujub. This is an amr, so I understand it as wujub, sami'na wa ata'na. This is a prohibition. I understand it as indicating tahrim. This is haram for me. Sami'na wa ata'na. Yeah, okay, so this is a good point. Muhammad Abdul Mun'im makes sense. Would this be different than marriage, because one is about money and the other is about, people's honor, and but dispute about that is something that's very serious. Yes, I would say absolutely, absolutely. Which is why you'll find that basically everyone says that having witnesses is an obligation, and the Malikis who don't say that having witnesses is an obligation, they say that it being well known and publicized is an obligation. So essentially, either way, the same purpose is achieved of protecting people's honor and their nasab from being accused of zina, and from because if a dispute happens and something like that, then it's a very serious matter. And clearly, then it's not the same. It's not the same as 25 cents worth of candy, clearly. And so, here having witnesses is an obligation, and here having witnesses is recommended. I want to share with you some quotes. These are about qara'in in general, and they're not necessarily quotes that are intended to be about qara'in for wujub and for Awamir and Nawahi in particular, because qara'in can be for doing ta'wil in other contexts as well. So you have Ibn Daqiq al-Eid, rahimahullah, in Sharh al-Ilmam, he says, قد تقوى القرائن وقد تضعف وتكثر وتقل وفيها مجال للنزاع فسيح. Qara'in could be strong, they could be weak. In other words, they vary in terms of their strength. You could have many qara'in in a particular issue or particular text, or few. وفيها مجال للنزاع فسيح. There's wide scope for dispute, meaning amongst fuqaha, there's wide scope for them to differ, to look at these and sort of come to differing conclusions about the qara'in that are attendant to a particular case. In another passage, Imam al-Juwayni, he says, لو رام واجد العلوم ضبط القرائن ووصفها بما تتميز به عن غيرها لم يجد إلى ذلك سبيلا. If a person who is seeking or who has knowledge of the ulum tries to list the qara'in and categorize them into distinct categories, he will be unable. لم يجد إلى ذلك سبيلا فكأنها تدق عن العبارات وتعبى على من يحاول ضبطها بها. Since they're so subtle that it's as if they're too subtle to be captured in particular terminologies that distinguish them into particular categories. So basically, he's saying that qara'in cannot be categorized, which is why I have this This is I think it's a master's thesis that was done at Medina University. It's very hard to get a hold of, so I had to actually photocopy it many years ago. It's called ضوابط صرف الأمر والنهي عن الوجوب والتحريم وأثره في الأحكام الشرعية. It's a decent study, and he's given many examples that he's collated from different sources. So what he's tried to do is to try and sort of categorize them. What Imam al-Haramain just said, that you can't really categorize them. He's tried to give categories for them. So I'll just quickly just give some of what he said. This is not all of them. He says that, so firstly, you could have qara'in that are actually connected to the text, or that are external to the text that you're looking at. So as an example of qara'in that are connected to the text, you have, for example, Allah subhanahu wa ta'ala says, addressing the disbelievers in Jahannam, ذُقْ إِنَّكَ أَنْتَ الْعَزِيزُ الْكَرِيمُ. Taste, you are indeed, honorable and noble. Meaning, the reason you disbelieve is because you thought you were too honorable and noble to join the believers. So now taste this punishment. This is sarcasm. This is mockery. So the command here is actually intended to mock the person. It's not actually a command to taste. So here, the qarina is present in the text. إِنَّكَ أَنْتَ الْعَزِيزُ الْكَرِيمُ. In a hadith, this is I think in Sahih Muslim, the Prophet ﷺ says, سَوُّوا صُفُوفَكُمْ فَإِنَّ تَسْوِيَةَ الصُّفُوفِ مِنْ تَمَامِ الصَّلَاةِ. Straighten your rows, for straightening the rows is from the completion of salah. So most fuqaha have understood this to be a recommendation. It's mustahab, it's not wajib. And they say that the tamam of salah is something that is external to the haqiqa of the salah. And so therefore this is recommending us to do something that is beyond what is necessary for the salah. And so it is mustahab, not wajib. So then he says for qarina that could be external, he says that could be other texts, and he mentioned specific qawa'id, but I'll just sort of summarize some of what he had said. So obviously you have one example was what we'd already discussed about commands coming after prohibitions. And then he says when you have different texts that need to be reconciled, so you do ta'wil of them so that they can be understood together coherently. Another one he mentions, of course, is ijma. Ijma, as we mentioned, there's sort of a paradox involved with ijma that, it's sort of a chicken and egg sort of thing. Which came first, the qarina or the ijma? Which came first, the interpretation of the command or the ijma about the interpretation of the command? And if the interpretation of the command is not wujub, which is what we're saying is the default, then there must have been some other qara'in before the ijma. That's an oversimplification because there's actually a response to that, but we'll leave that for now. But ijma, so he mentions ijma. So we have, when it comes to, so we have, so far from what we said, there are textual clues inside the text, then there are external qara'in. External qara'in could involve other texts in various different ways. It could involve ijma, it could involve qiyas, it could involve principles of the shari'ah. This is what is listed. He also mentions madhab al-sahabi, but obviously then there's a dispute about is the madhab al-sahabi is hujjah, is it not hujjah? And then a qarina that he mentions is mukhalafat al-madhab. I'm not sure what exactly he said under that, but I assume that he went on to say that this is not very strong. But some scholars might say, well, this goes against that our madhab ruling is this, and so therefore, based on that, they do sarf of some of the text. So that obviously is kind of a ridiculous one. But I want to come back and talk about qiyas. When it comes to interpretations of the text, qiyas obviously plays a very important role in interpretation of text. But beyond qiyas, even where there's not necessarily a qiyas involved, ta'leel still plays a very important role in interpretation of the text. And this is something that is, I think, oftentimes overlooked. Ta'leel. Ta'leel, what is ta'leel? What do we mean by ta'leel? So qiyas, you'll remember, well, I guess we haven't actually gotten into qiyas yet. So the idea of qiyas is that you have an original case that has a ruling that is established in the Sharia text. You're extending that ruling to a new case. So you have the asl, is the original case. You have the hukam of the asl, which we're saying is the hukam of the new case. The new case is called a far. So basically in qiyas, you have asl and far. The original case, the new case, the hukam that is extended from the first case to the new case, and you have an illah. An illah is an underlying meaning or quality that is present in both cases that we're saying that this is the effective cause for why this hukam was present in the first case. Because this meaning is present in the second case, we are extending the ruling to the second case. This is called illah. Illah, or the legal reason for a ruling. So ta'leel is the idea of discovering the illah, or the legal reasoning underlying a ruling. So ta'leel, even where there's not actually necessarily qiyas involved, we're not looking at other cases, we're just looking at the text itself. Understanding what is the illah of the hukam might help in interpreting that hukam. So with the example that we discussed about the difference between seeking witnesses for marriage and seeking witnesses for sales. Obviously, looking at the gravity and the purpose that is intended to be fulfilled by both of these things gives us an idea of which one is weightier, and so therefore it should be regarded as an obligation, and which one is simply a recommendation. Understanding the illah of the hukam actually has an important role in understanding the gravity of the hukam, the importance of the hukam, the function of the hukam, and so therefore, is it a binding hukam or a recommendation? This is why you will find, generally speaking, most issues that are related to adab, basically good manners or perfection of supplementary things that are not essential matters of morality or immorality. They contain no harm to yourself, or no serious harm to yourself or to others, transgressing of others' rights. These are things that are intended to sort of help perfect us. And so this is why the fuqaha have generally understood commands related to adab to be recommendations. Understood commands related to adab to generally be recommendations. And obviously the prohibitions to be karaha, dislike rather than actual tahrim. So this is highlighting this point because you might at some point in your studies hear someone say that commands related to adab are obligatory. And this is the default because this is the default of obligation. The default of commands is that they're obligatory. And there's no evidence that adab should be treated otherwise unless there's a qarina, and there's no qarina. And the answer to that would be the fact that this particular action is an adab. It's not something that is fundamental, but is an adab, is in and of itself the qarina. It is in and of itself the qarina. And so this is why if you look through the books of the fuqaha, you'll find that majority of things that are related to adab, the fuqaha have treated as being mustahabbat and makruhat rather than wajibat and muharramat. This is generally speaking. Let's take another sort of case study. I'm not going to go into the actual specific details, but we have a host of things that have been encouraged in the Sharia or discouraged in the Sharia because they relate to tashabbuh, imitation of the kuffar or resembling the kuffar. Someone might say that anything that the Prophet ﷺ has prohibited because it involves prohibition, because it involves tashabbuh of the kuffar, imitation of the kuffar, should be haram. And anything the Prophet ﷺ has commanded so that in order to ensure that we are different from the kuffar, different from the mushrikeen, should be an obligation. After all, didn't the Prophet ﷺ say, "Man tashabbaha biqawmin fahuwa minhum"? Whoever imitates a people, he is from them. Isn't that a very severe statement? Is the apparent meaning of that is that a person who imitates a kafir is a kafir. A person who looks like and walks like the kuffar is a kafir. فَهُوَ مِنْهُمْ, he is one of them. It's very severe. Taken at the zahir, it's very severe. So therefore, should not the default concerning issues of tashabbuh, issues that are related to tashabbuh, should not the default be wujub and tahrim? That's what one might expect, is it not? But if we look at the actual rulings of the fuqaha across the four madhahib, we find that the opposite is the case. As a general rule, this doesn't mean that all issues are like this. So as a general rule, you'll find that things that are that the Prophet ﷺ has commanded or that he has prohibited in order to ensure that we be different from the kuffar, you'll find that the fuqaha and the shurah of the hadith have generally interpreted the majority of these things to indicate recommendation or to indicate discouragement rather than actual prohibition. How do we reconcile that? It comes back to what I mentioned, which is understanding the ta'leel, understanding the function of the hukam, and the place of the hukam relative to the rulings of the sharia. So individual acts that might involve resembling the kuffar, like for example, the Prophet ﷺ mentioned that the Jews don't dye their hair. So dye your hair. When it becomes white, you should dye it. And as far as I'm aware, pretty much all of the fuqaha, if it's not actual ijma, say that this is not an obligation. It's not an obligation to dye your hair if it turns white. It's recommended. Yes, it's recommended. Prophet ﷺ tied it to resembling the Jews, yet it's not an obligation. You might even see famous scholars until today who don't actually dye their, whose beards have become white, their hair has become white, and they haven't dyed it. And ulama from the Salaf who didn't necessarily dye their hair, and through the ages, who didn't dye their hair when it became white. And a host of commands and prohibitions that are like this. So, for example, the Prophet ﷺ, he said that the Jews do not pray religiously; they don't pray in their sandals. So pray in your sandals. Again, the purpose of this praying in the sandals, the Prophet ﷺ tied it to being different from the Jews. But you'll find that many, it's not many, it's probably all of them, pretty much no one understood this to be an obligation. Actually, Juwayni and his followers understood this to be an obligation. It's an interesting anecdote. They understood this to be an obligation, and then they debated, what is this obligation? And some of them, they concluded that, well, Al-Amr la yaqtadi takrar. Al-Amr doesn't to fulfill an obligation doesn't require a repetition. So the obligation is fulfilled if you pray in your shoes once in your life. And they used to actually cause a big fuss coming into the masjid and praying in their shoes, coming into the Masjid al-Haram and praying in their shoes. It's amazing fiqh. They have the qaida, you apply the qaida. Al-amr mutlaq yaqtadi takrar. Where's your qarina? Ya akhi, where's your dalil? The dalil is clear. صلوا في نعالكم. الأمر المطلق يقتضي الوجوب. الأمر المطلق لا يقتضي التكرار. Go one time. Allahu Akbar. Fiqh. This, look at the fiqh. I have a saying. I've run into people who actually defend Juhayman. It's really bizarre, but there are people out there who defend Juhayman. I think maybe it might be less than it was, say, about 10 years ago, 15 years ago. But there are these people who defend Juhayman. And so, they're basically, the idea in their defense is always that, he made his ijtihad, he was just following the dalil and he made a mistake. And look at all the good points that he has. I don't care what good points he has. Man killed people in the haram. So, what I say is, yes, he was following the dalil. Look at where it led him. Led him to the haram. Killing people in the haram. So, it's good to follow the dalil if you actually understand the dalil and are capable of understanding and interpreting the dalil. Otherwise, stick around for the end of Al-Waraqat when we discuss ijtihad and taqlid. This is not something that happened just with Juhayman. This thing about insisting on praying in the shoes, even in a masjid where there's a carpet and the shoes will bring in mud and get mud in the carpet, and then the carpet starts stinking. This is actually not something that would just happen with Juhayman. Something that continues to our time, due to amazing fiqh that some people that take these principles in a very superficial manner and start deriving rulings on their own. The Prophet ﷺ said, "Sallu fi ni'alikum," at the very least, this is recommended. And your carpets are of no concern to my dalil. I have a clear dalil, and I'm going to follow it. This is the sunnah. Which is absurd. It's absurd. But it comes back to this problem of not understanding the reasons and purposes and functions of the ahkam. So coming back to the issue of tashabbuh, and this brings us to Saad's question, and we'll basically wrap up with this. So Saad had asked, find this question. It says, regarding the issue of the beard being sunnah or wajib, one argument I've heard is that since growing the beard returns back to adat and not ibadat, the command to grow the beard is interpreted as a recommendation. In that case, would being an ada be a qarina for nadb? Incidentally, it's worth noting that even amongst scholars who say that shaving is haram, like for example, the mu'tamad of the Hanbali madhab, that shaving the beard is haram. Shaving the beard is haram, but i'fa, which is what is mentioned in the hadith, i'fa al-lihya, is mustahab. So don't assume that just because some scholars are saying that shaving is haram, that they've understood that this particular command in this particular hadith is an obligation. You have some scholars who have understood it that way. So you have, for example, Ibn al-Humam, and this becomes sort of the mu'tamad for the Hanafis, says that i'fa is wajib. He understands i'fa as basically being a fist-length beard, a qabda. So you do have this opinion, but that doesn't necessarily mean that those ulama who were saying that shaving is haram necessarily considered that i'fa is wajib. And you'll find that that this is also indicated by the fact that the ta'leer that the Prophet ﷺ gave for i'fa, when he said a'fuwan liha, he mentioned that it is to be different from the kuffar, be different from the Majus, or be different from the mushrikeen or what have you. So here he tied it to the tashabbuh. But you'll find that some of them, when they say that shaving is haram, the ta'leer they will give is that this is a type of muthla. It's like a type of mutilation. Or in some cases, you find some of them, like for example, some of them say that shaving the beard is haram because no one does it except the mukhannathun, people who are effeminate, people who are androgynous, people who basically are not reflecting masculine behavior. So a person who shaves the beard will be considered effeminate, will be considered, of questionable. Basically, this will be considered a behavior that is feminine behavior, and so clearly that is a reason for tahrim. But it's different from what is mentioned in the hadith, and it's tahrim of halq, tahrim of shaving. It's not about the command to grow the beard. A'fuwan liha. Another thing that is worth mentioning, a'fuwan liha, the hadith also mentions, the same hadith that mentions growing the beard mentions the trimming of the mustache. And I'm not aware of anyone, at least amongst classical scholars, because I've seen some contemporaries who say that it is wajib to trim the mustache, but this is, again, just some contemporary individuals. I'm not sure about classical scholars. I don't think anyone says that trimming the mustache is an obligation. Yes, it's a sunnah, it's recommended because of the hadith, but an obligation? Yeah, so there's difference of opinion about what exactly is meant by trimming the mustache. What exactly is the sunnah regarding this? Some of them say that it's simply you should not let it come down on your lip, and some of them say it should be trimmed very close. And this is based on different narrations. Inshallah, both are sunnah. Incidentally, this narration about Umar having a long mustache such that he would, I think the narration says that he would twirl the end of it like this. At-Tahawi responds to this in Sharh Ma'ani al-Athar or Sharh Mushkil al-Athar. He says that this is when it would grow out, it would become that long, and then you would trim it. So, it's not my purpose here to give a particular ruling about shaving the beard or about fa, but just to sort of understand this issue that, so for example, you have the Shafi'is, the mu'tamad of the Shafi'iyya is that shaving is makruh. Shaving is makruh. And fa is mustahab. Fa is mustahab. Letting the beard grow, growing a full beard is mustahab. Shaving is makruh. So those who said that shaving is haram, at least many of them, I don't think they were taking it from the fact that there is a command to grow the beard. Some of them say that it's haram to shave the beard, like the Hanabila, they say that it's haram to shave the beard, but they don't actually obligate i'fa. The i'fa basically being understood as a full beard that is fist length or longer. They don't obligate that. They recommend it. And you'll find similar from Maliki scholars, and also there are Maliki scholars who said that shaving is makruh. Others said that shaving is haram. I think the mu'tamad for the mutaakhirin, the Malikis, is that shaving is haram. But there are some of them like Qadi Iyad who said that it is makruh. But even with them prohibiting shaving, saying shaving is haram, I don't think that they're obligated i'fa. They're obligated growing a full beard. And someone can check that, but I don't believe that they did. So, this is something that is related to tashabbuh, and it's another example where if you actually look at it, the hukum has not been understood as an obligation. It's not been understood as an obligation. And it's also worth mentioning, even those ulama who said that shaving is haram because it's only done by mukhannathun, it's worth asking, based on this ta'leel, is this hukam intended for that urf, that it is haram in that urf? Because in a society where most men shave, or it's common for men to shave, and it's not seen as something unusual, it would not be a sign of being a mukhannath, right? So it does then imply that for those ulama that based on different customs, the ruling might actually change. It wasn't really my intention to get into the beard issue, but Saad asked the question, and it is related to this idea of qara'in, and it is also related to tashabbuh. The last thing I'll say about this is that when it comes to the i'fa is in adab. It's adab related to how you should keep your hair. It is something that doesn't involve any intrinsic harm. You're not transgressing against anyone's rights. It's your own hair. You're not harming yourself in any way. The hair will grow back. So there's not any reason that is present that merits considering i'fa or the ruling of trimming, being that even trimming the beard less than a full beard would be haram. As for shaving, as I mentioned, those who said that shaving is haram, they have other reasons. Either they say that it's mithla, or they say that it resembles, that it involves resembling the mukhannath. So Allah knows best. I had actually a couple more slides that I was intending to get to, but it's a lot of time here now, so I think we'll conclude with that. Are there any other questions before we wrap up? Sure. Ideally, usul questions rather than fiqh questions. Unless it involves an usul application.
Yeah, I think it involves something. You can judge for yourself, but when it comes to tashabbuh, you mentioned how generally the fuqaha mentioned that tashabbuh bil kuffar related to it would be in the category of mustahab or / makruh versus haram or wajib. And then over here, when we're talking about like a tashabbuh bil mukhannathin or bin nisa or whatnot, like with that specific example that you mentioned, with the beard, you said some of them would say it's haram of tashabbuh bil mukhannathin, right? So what's the illa difference between them, or what happens there?
Okay, that's a very interesting question. When it comes to, for example, tashabbuh bil mukhannathin, or tashabbuh bin nisa, tashabbuh rijal bin nisa, or tashabbuh nisa bil rijal, men imitating women or women imitating men, in things that are distinctive to men. This is something that I think, I don't want to be blunt about it, so I'll just sort of put it in a roundabout way. It's something that clearly it's related to something that involves matters of morality and moral behavior and immoral behavior. And so this is why it's treated more severely. Whereas a Muslim simply resembling non-Muslims in some respects, or in putting it another way, encouraging a Muslim to be distinct from non-Muslims in certain respects is a matter of reinforcing his distinct identity as a Muslim. And that identity as a Muslim can be reinforced in other ways. It might be that a certain person, for example, lives in America, happens to be, let's say, clean shaven and doesn't pray in his shoes and doesn't dye his beard or doesn't dye his hair when it turns Obviously, he's clean shaven, he doesn't have a beard, but he doesn't dye his hair when it turns white. Yet, he's very proud and reassured of his Muslim identity, and he prays 5 times a day. This idea of reinforcing that distinctness of identity is achieved. These things serve to reinforce that purpose, and they're encouraged to reinforce that purpose. But in and of themselves, if they're not something that is immoral or harmful, then they're simply adab that are encouraged. Allah Alam. So when it comes to tashabbuh, for example, things that are distinct to the religion of the kuffar, so things that are distinct to the Christian religion, that are religious in nature, yes, those are haram to get involved in. But things that are strictly of a secular nature are of much less significance. Also, there's something to consider that when it comes to resembling groups of kuffar, inevitably you're going to resemble in some way or another some group of kuffar or another. Are there not groups of kuffar who, for example, keep big beards, like Eastern Orthodox priests? I mean, they've got the ifa down. So if you're at any given time, if you're doing something that is going to be different from one group of kuffar, there might be other groups of kuffar that happen to agree with that. So you can't be different from all of them in all things. So you can't consider each and every single one of those instances to be an obligation. I hope that makes sense. I hope I'm actually making sense. Okay.
Sheikh, I had a question, if that's all right. Regarding, so we're looking at it very critically, and we're saying that, everything has a qarina. Suffice to say, like everything has some sort of qarina that we're using, and in the example where we said that, for example, of the two witnesses in business, we could make the example like sensibly speaking, like the candy example you gave. But couldn't one say that's a qarina in and of itself too, because we're using some sort of maybe qaida or some, la yukallifu Allahu nafsan, something that we're using that could be like, I'm trying to find something that would not need a qarina at all, and that seems to be like an impossible task. Do I have it like the line of thinking here correctly?
I mean, I'll say this for the sake of argument, which was what I said towards the end of this discussion, which is that regardless of whether or not there actually are awamir that don't have qara'in, the very least that can be said is that the job of the faqih, the real faqih, is to look for the qara'in and to think about them carefully and to examine them and then reach a conclusion. If a faqih has exhaustively examined an issue and thought about all of the possible qara'in that could affect that issue, and has not come up with anything that clearly affects the interpretation of that command, or he's come up with different factors and he doesn't see one of them being really more weighty than the other, here, fine, go with wujub. But a faqih who, and when I say faqih, I mean a mujtahid who simply looks at an amr and says, this amr is mutlaq, so I'm just going to assume that this is wajib. Nobody told me otherwise. I'm not aware of anything else. It's good enough for me. That's not ijtihad. That might be sufficient for a faqih in the sense of a faqih who is writing a book of fiqh explaining the issues of his madhab, because he's not necessarily mujtahid, So he's presented with the text. He's not aware of any qara'in. This in our madhab, we said this is wajib. والأمر المطلق يقتضي الوجوب. Fine, I don't have a problem with that. Unless someone can show me other qara'in that tilt the scale the other way, I mean, I'm not going to think twice about it. والأمر المطلق يقتضي الوجوب. Even more than that, what you'll find is that in the books of fiqh, that that oftentimes that when mentioning a ruling, this is across all four madhabs, oftentimes you find that when mentioning a ruling, a particular ruling will come up and they say this such and such is mandub. What's the evidence? They'll quote a hadith or an ayah that has a command. So well, amr lil-nadb. They don't mention a qarina. They say well, amr lil-nadb. This is how we understand. This is how our fuqaha understood it. This is the amr lil-nadb. The dalil is this amr, but this is one of the dalils. This amr. Well, amr lil-nadb. Why is it lil-nadb? What's the qarina? Because he's either because he feels that the faqih will understand why this command should be understood as nadb, or because he's a muqallid and he feels that it's not his job to actually do ijtihad to produce a qarina. You oftentimes find that they haven't done so. But when it comes to making ijtihad, that's not sufficient. That's not sufficient. Ijtihad requires someone make real ijtihad. Ijtihad means exerting your full effort. Literally, the linguistic meaning of ijtihad is to exert your full effort to reach a ruling. And so that would involve investigating the Quran. And it might very well be that the actual cases where there is no qarina whatsoever, or the qara'in are absolutely equal, those might very well be simply rare cases. Allahu a'lam. In any case, that was intended as food for thought so that people don't simply take texts that they find and run with them and say that, this is an obligation. And, the fuqaha said that this is mandub, but it's actually an obligation because al-amr al-mutlaq yaqtadi al-wujub, as if the fuqaha didn't know this qaida. As if, you've made some amazing discovery that don't be in a rush. Don't be in a rush to reach a conclusion. If when it comes to actually making ijtihad, it involves much more than that. Wallahu a'lam. In any case, just to wrap up, this discussion of awamir and nawahi, oftentimes you'll find al-amr and nahi and al-amr yufidu al-wujub illa إذا صرفته قرينة والنهي يفيد التحريم إلا إذا صرفته قرينة. These qawaid are mentioned oftentimes in the books of usul al-fiqh in very brief fashion without going into much detail at all. Just these brief explanations. You hardly get more than that. Other than you will get some issues that are specific issues like al-amr ba'd al-hadr, which you could say is a specific type of qarina. You'll get some of these issues like this, but generally what you'll get is these very brief statements. But the actual fiqh that underlies the understanding of awamir and nawahi, it is sort of the heart of fiqh. It's interpreting awamir and nawahi and determining whether they're intended to be obligation, recommendation, permission, karaha, or a dislike, or prohibition, legality. And this is at the very heart of fiqh. And so this is one thing that I feel that many times the usul fiqh books, they fall short in giving the student a proper understanding of this premise. الأمر للوجوب إلا إذا صرفته قرينة للندب أو لغيره والنهي للتحريم إلا إذا صرفته قرينة إلا الكراهة أو غيرها من المعاني. The principles are valid principles, but the brief nature of the discussions oftentimes leaves a great deal of vagueness, which is why you find that some people today, when they try and apply this themselves, they get confused. Or even if they're doing taqleed. I mean, I know from my experiences as a student and with other students that this is something that sometimes students find themselves scratching their head over. This is what we learned in Usul Fiqh. Now I'm reading in the books of Fiqh, and here's a ruling here. This is nadb, this is this, this is this. But what's the qarina? I don't know. It's not explained in the book. And so this is something that causes a lot of I think it's a gap that is present in the understanding of many students and many aspiring scholars in understanding this very important topic of usul fiqh. So, although we're going through al-Waraqat and it's a very brief text and our lessons are fairly brief and we're covering these topics in not in too much detail, still this discussion that we've had is an extremely, extremely important discussion. And I've just scratched the surface. We're just scratching the surface with these discussions. The real fiqh of this bab, you'll understand it when you read deeply and ponder deeply in the shari'ah, the nusus of the shari'ah. Read the Quran, read the hadith of the Prophet ﷺ. See how did great mufassirin interpret these ayat that contain ahkam or that are related to ahkam, starting from Al-Tahawi, Al-Jassas, Ibn al-Arabi. Look through the commentaries of the Sunnah. Ibn Hajar, Al-Nawawi, Ibn Abdul Barr, Al-Maziri, Al-Qadi Iyad, Ibn Daqiq al-Eid, Al-Iraqi, and so on and so forth. Read deeply in these things and ponder and try and see how the theory that you're learning, how scholars are applying it. And along the way, try and get a sense for how it works for yourself. Let's conclude with that. سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت أستغفرك وأتوب إليك. صلى الله وسلم على نبينا محمد.